Hello, everyone. Jax West over here now to go over the state's response to Kathleen's filing of the new witness and wanting a stay and remand. And we'll see if I'll be, well, while I'm reading, I'll say this, I always gotta say this, while I'm reading this, I can't, I'm not looking at your comments if I'm even able to see them. Woohoo! There's Debbie McFadden. Because for some reason, everything works just fine on Stephen Avery Project, but when I come live here in MAM Gossip, the live is completely different and doesn't work as well. And then I've had several people tell me that they're not even able to comment in here. So I don't know. So, all right. So I'm sure everybody knows that we saw that there was something filed on Friday and we were all desperate to know what it was. I reached out to the clerk, and now the clerk emailed me today and then emailed me this. And so what this is it is the state's response to Kathleen's filing. So this is not a ruling, a court on any level saying anything on this. This is just the courts or the states bitching about it, basically. And I guess it's written by Josh, the first letter. So, dear Ms. Rife, who is the clerk, enclosed for filing in the above matter are the original and 4 copies of the response in opposition to Avery's 4th petition. And since we're in gossip, this is where I'm going to pause a whole lot. If you want to just hear this without my commentary, I did it for the most part on Stephen Avery Project, where I try not to bitch too much. But in here, I'll be pausing a whole lot and then forgetting where I was to bitch about it. So by them saying of the response in opposition to Avery's 4th petition, that's them trying to say, look at all this, pointless crap is what they're trying to claim. 4th petition to stay this appeal and remand this case to the circuit court. A copy of this response has been served by mail on counsel for defendant appellant. Sincerely, Lisa E.F. Comfer, Assistant Attorney General. Also, before I start reading this, these filings are always stating motion numbers and other cases. I'm not going to read those numbers. I'm not going to read those other cases. A lot of times when I'm reading something and then it's the numbers for whatever statute it is, I just say blah, blah, blah. And then I've had people attack me going, oh, that's not professional. Well, I don't really care. I'm not a professional. So, and does it matter to you if you hear what numbers this statute is? No, you don't care. So I'm trying to read these 23 pages as quickly as possible to take out the bullshit. So, response in opposition to Avery's 4th petition to stay this appeal and remand this case to the circuit court. Introduction. Plaintiff respondent, State of Wisconsin, opposes defendant appellant Stephen A. Avery's 4th petition to again stay this appeal and remand the case to the circuit court for consideration of by saying consider of yet another Wisconsin statute. Being so condescending and passive aggressive. For consideration of yet another Wisconsin statute motion alleging that the state violated Brady versus Maryland by allegedly failing to inform the defense that a Thomas Sawinski purportedly called law enforcement on November 5, 2005 to say he saw Bobby Dassey moving a car similar to the victim's car. The motion on its face shows that it was filed in violation of Wisconsin statute blah blah. applicable here via Wisconsin statute because it was filed for an improper purpose and without a reasonable inquiry into its factual basis. Staying this appeal and remanding for the litigation of such a motion would result in further unnecessary delay in litigation. Okay, so let me pause right there. Really? Unnecessary delay in litigation. This whole thing is unnecessary delay. Stephen has been in jail and then prison since 2005. So, Stephen is the one who is suffering in all of this, not you, state. This appeal has been languishing for nearly 4 years now, due entirely to Avery's repeated requests to return to the circuit court to litigate procedurally barred claims that have had no factual support. It is reasonable to conclude at this point that he is not pursuing these claims in good faith, but is merely, quote, throwing the proverbial spaghetti against a wall to see what sticks, unquote, and delay resolution of this case. Stephen is not trying to delay anything. Stephen has evidence after evidence that they keep trying to submit, more things proving his innocence. So, and why would he want to delay a ruling? He doesn't want to delay a ruling. He wants to make sure before there's a ruling, all evidence is there. Because does he really want this? We want them to rule against him here and then have to start all the way over and work his way back up, causing more time and delay? No, so here it all is. So consider it all right here and let him go home. Indeed, Avery's new claim is not only unsupported by even a suggestion of corroborating evidence, but this claim is also mutually exclusive with many of the other claims Avery has pursued in the circuit court and on appeal. All of these allegations cannot be true. Oh yeah, they can. Avery's reckless disregard of the truth or falsehood of the allegations he is submitting to the courts alone should be reason enough to deny his petition for remand. No, wrong. Okay? So, and I'll rant about this over and over again, but you have the bones, the alleged Teresa Halbach bones that were at the gravel pit, not the quarry, the gravel pit that's even farther away, that they gave to the Halbach family, that Kathleen Zellner didn't know they did. When she took the case, she was negotiating with the state to get the bones and the RAV4 for her testing, and that the state said they were going to give her. Meanwhile, the state knew, well, they gave the bones to the Halbach family to do with whatever they did with it. Don't know why they're allowed to keep the RAV4 away from her. But that's a violation. You lied to her. And she finds out later you lied to her. She even has, when the one dude meant to call another guy and called her on accident and left a voicemail on her machine. So they're caught in a lie on the bones. So now you have this guy who said he came forward in 2005 and was told we already know. So you're hiding stuff. Moreover, this case has now been fully briefed in this court for nearly a year and has been submitted to this court awaiting a decision for nearly 5 months. Whose fault is that? Remanding this case to the circuit court to again allow Avery to develop another entirely new constitutional claim is not necessary to decide this fully briefed and long submitted appeal. It's not fully briefed if you didn't know this witness existed. But somebody in Manitowoc did, because he called and was told, we already know. It would be inefficient and waste the courts and the parties considerable resources that have already been expended and further delay this appeal's resolution. Who's in prison? Stephen. Any delays, Stephen is who suffers. Dolores is who suffers. The state doesn't suffer. If Avery wishes to pursue yet another claim, the appropriate course is to either wait until this appeal is concluded, conduct a reasonable investigation, and file a new Wisconsin statute blah motion, or dismiss this appeal so he can pursue it now. Either way you do it, it's a delay in time. Delay in game, no matter which way you do it. So on his current course that he's on, since that can't just take new information up there, you have to pause it, go back down to court, and submit it there. And get it so then it can go back to this court and now be considered. Instead of, oh, well, let's have this one rule without this new information. So let's have this one rule without all the facts, without all the evidence. And then they deny it. And then you start all over again. But now you can't use any of that stuff that was denied. Shouldn't there be all the evidence included? If Avery has a sufficient reason why his new claim could not be raised in any of his previous 6 motions, because they didn't know about him, and some facts to support it, then the claim will not be procedurally barred when this appeal is concluded. So, again, the state is just trying to push for the higher court to give its decision without this information being included. That's what they're so desperate in doing, and saying that, well, this stuff could still be brought up later. Well, why wouldn't you bring it up now? Why do you have to wait for this one to go when there's new evidence? I'm a broken record, but no matter how you do this, there's time involved. If not, the claim is unquestionably procedurally barred already, and another remand would serve only to further delay this litigation and add another incongruous claim to Avery's appellate brief. Avery has dragged this appeal out long enough. No, he hasn't. Stephen hasn't dragged out anything. Kathleen Zellner hasn't dragged out anything. It's the court. Without having a set time limit on when to give decisions, and that who is delaying and dragging out everything. He should either dismiss this appeal, conduct a reasonable investigation into his new claim, and pursue it in the circuit court now, or this fully briefed, submitted, and years stagnant appeal should proceed. Background. In 2007, a jury convicted Avery of first-degree intentional homicide for the murder of Teresa Halbach and for possession of a firearm as a felon. Let's stick a pin in that right now. So something to remember is, in Stephen's case, there is no rape. In Stephen's case, there is no mutilating a body. He wasn't found guilty on mutilating a body. So they do not believe that Stephen put her in the fire. That's not in there. What they originally took him in custody for is the firearm for being a felon, due to when he pulled his cousin over and pointed a gun at her. So there is a gun in his trailer hanging in a gun rack that was over his bed, which was not his property. Most of the stuff in that trailer is his landlord, Raleigh Johnson's, who's a friend of Ellen Avery's. So, but because that gun is there, that's what they used to get Stephen, which Stephen didn't understand. He couldn't have a gun as a felon because they would give him a hunting license. So how do you get a hunting license if you're a felon and you're not allowed to have a gun? So I will totally have Stephen's back on that, on being confused that he's not allowed to have a gun in his possession if you're going to take his money and give him a hunting license. But that they just wanted to get him into custody. They had nothing on him for Teresa Halbach, so they used the gun and that he's a felon to take him into custody. And then they charged him with that in this case, in the Teresa Halbach case. So Stephen would have been doing time regardless because of the gun. So technically, all the years he's been in prison aren't wrongfully incarcerated, I guess. I don't know what words to use there. Because they got him on that charge. His direct appeal concluded when the Wisconsin Supreme Court denied his petition for review in 2011. In February 2013, Avery Pro Se filed a Wisconsin statute motion alleging that the state had interfered with his ability to confer with his attorneys, that the state impermissibly commented on his silence during closing argument, that he was deprived of a fair tribunal, and ineffective assistance of counsel. Yep. Check. The circuit court appointed an attorney to investigate the claims and ultimately denied the motion without a hearing in November 2015. Just because somebody was appointed and it was denied doesn't mean the court was right in that. In June 2017, Avery filed the Wisconsin statute blah motion at issue in this appeal, alleging that a multitude of constitutional errors occurred in his prior proceedings. The circuit court denied his motion without a hearing on April 3rd, 2017. Which I again think this is always such bullshit. Shouldn't all the facts be considered in everything? So you deny a hearing to hear anything about it. Nope, we don't want to hear from Stephen. Avery then filed a motion to vacate judgment on October 6, 2017. He additionally filed a motion for reconsideration on October 23, 2017, followed by several supplements to that motion between October 31 and November 17, 2017. The circuit court denied all of these motions without a hearing on November 28, 2017. Yeah, again, showing more bullshit. Avery filed a notice of appeal from the circuit court's final written order on November 30, 2017. On June 7, 2018, this court retained jurisdiction but remanded this case to the circuit court to allow Avery to file another Wisconsin statute motion to litigate a Brady claim. The circuit court denied that motion without a hearing as well, and the record was transmitted back to this court on September 25, 2018. Well, see, maybe if you would stop denying just hearing what evidence has come forward, there wouldn't be all this delay in all these filings. On December 17, 2018, Avery filed another petition to stay this appeal and remand the case to the circuit court for Avery to litigate a motion for post-conviction DNA testing of bone fragments collected before trial pursuant to Wisconsin statute. Why do I keep saying November? On December 28, 2018, this court denied the petition, stating that, quote, the scope of this appeal is limited to a review of the circuit court's orders denying Avery's Wisconsin statute blah motions, unquote, and therefore, quote, good cause to remand had not been shown, unquote. This court gave Avery a further extension to February 1, 2019 to file his initial brief. Again, it's proven. There's documentation that they had been negotiating with Kathleen Zellner to give her these bones for her to investigate when they knew years prior, before Kathleen was involved in the case, that they had given the bones to Karen Halbach. And then it's like, nope, we're not going to hear about that. Real proof that the state lied, covered up, and destroyed evidence. On January 24, 2019, a week before his initial brief was due, Avery filed a third motion to stay this appeal and remand the case to the circuit court. This time, he sought to pursue a new claim that the state violated his due process rights by releasing a portion of potentially human bone fragments. They don't even say that, the state doesn't even say those are real bones. To the Halbach family for burial. Well, if they're not real bones, why are they going to the Halbach family? Roughly 5 years after Avery's trial, this court again remanded the case to the circuit court to allow Avery to pursue this additional claim. The circuit court denied it without a hearing on August 8, 2019. This appeal then finally proceeded. The briefing was concluded June 26, 2020. On November 9, 2020, the case was submitted to this court on briefs. The only step left in this appeal is a decision from this court. On April 12, 2021, long after briefing had concluded and after this case had been submitted to this court for 5 months, Avery submitted yet another motion for remand. This time he claims that a new witness, Thomas Sawinski, had come forward to post-conviction counsel on April 11, 2021, and then there's a footnote that says Avery's motion says Sawinski came forward on April 11th, 2021, but his affidavit is dated April 10th, 2021. Oh my, the state has something wrong. Kathleen has something wrong, unlike, the state a million times over. And said that while he was delivering newspapers to the Avery salvage yard on November 5, 2005, he saw Bobby Dassey and an unknown older man pushing a RAV4 up a hill. I don't recall it saying up a hill, and I have read it I don't know how many times now, and I don't remember it saying up a hill. Maybe I'm wrong. Avery claims that Sawinski called the Manitowoc police to report this later in the day, but police, and I don't recall it saying he called Manitowoc police either, but police were not interested in this information. Avery claims the state suppressed this information and therefore violated Brady. He seeks remand to pursue this claim in the circuit court. Yeah, that's what it is. Relevant law. Avery is permitted to petition this court, quote, for remand to the circuit court for action upon specific issues, unquote, pursuant to Wisconsin statute, blah, blah, blah. The decision to remand is left to this court's discretion. The rules of civil procedure apply to appeals and to litigation of Wisconsin statute, blah, motions, provided they do not conflict with any specific rules of procedure spelled out elsewhere for such actions, and the context of the rule does not manifestly require a different construction. As relevant here, Wisconsin statute blah, and then there's a footnote, and the footnote says, A, the paper is not being presented for any improper purpose, such as to harass or cause unnecessary delay or needless increase in the cost of litigation. B, the claims, defenses, and other legal contentions stated in the paper are warranted by existing law or by a non-frivolous argument for the extension, modification, or reversal of existing law or the establishment of new law. C, The allegations and other factual contentions stated in the paper have evidentiary support or, if specifically so identified, are likely to have evidentiary support after a reasonable opportunity for further investigation or discovery. All right, back up to where I was before the footnote. Provides that by presenting a submission to the court, an attorney is certifying, quote, that to the best of the person's knowledge, information, and belief, formed after an inquiry, reasonable under the circumstances, all of the following. And then that footnote again. The purpose of this statute, there is a fourth prong to Wisconsin statute, blah, blah, but it is related to pleading defenses and so does not apply here. The purpose of the statute is to, quote, to place a professional obligation on the attorney as an officer of the court to satisfy, in brackets, herself, that there are grounds for the action, defense, or motion, unquote. Quote, the duty to conduct a reasonable inquiry mandates, unquote, that an attorney validate the facts being alleged before the proceeding with a claim. The reasonableness of an attorney's inquiry into the facts supporting an allegation is determined by considering the following factors. 1, quote, the amount of time the attorney had to investigate the claims, unquote. 2, quote, the extent to which the attorney had to rely upon his or her client for the underlying facts, unquote. 3, whether the case was accepted from another attorney, unquote. And 4, quote, the complexity of the facts, unquote. This provision has intentionally been crafted to replicate Federal Rule of Civil Procedure 11. Accordingly, courts can also look to cases interpreting somebody was pulling my door. Interpreting that rule when applying Wisconsin statute, blah, blah. Argument. Remanding this case for Avery to pursue another new constitutional claim at this late juncture would be inefficient and unduly prolong this appeal. Again, I don't understand that. Because no matter what, there's going to be more time involved because a new witness has come forward. So what difference does it make if you put a pause, because there's new information here. We don't know what investigating Kathleen Zellner has done with this new witness, but we also know the judge has had this case for months and months and months, right? That's what they keep saying. You've had it since this time. So for all Kathleen Zellner knows, the judge could be giving a decision today. So are you going to take time to do this long investigation into this guy's claims before you want it submitted to the judge that, hey, wait, there's something else going on? Makes perfect sense to me. Knock it off. Sorry, dogs. Avery again asked this court to stay his appeal and remand his case to the circuit court. Mickey, no. So he can litigate another new Wisconsin statute motion. The issue Avery claims he would like to pursue is an entirely new claim alleging a Brady violation based on a purported new witness who provided post-conviction counsel with an affidavit on April 10, 2021, alleging that he told law enforcement about seeing Bobby Dassey moving a car on November 5, 2005 that resembled the victim's vehicle. I would think that would be important. I would think if you're the state, you would want to know about that too. Because see, shouldn't everybody care about getting justice for Teresa Halbach and finding out what happened to Teresa Halbach? So if a new witness comes forward on April 10th of 2021 of a case that occurred allegedly on October 31, 2005, you would think the state would care. As before, Avery does not seek remand for fact-finding on a specific issue raised in his earlier motions. His motion is another request to pursue a new constitutional claim. Yeah, because there's a new witness and new evidence. Avery admits that this is a new issue that counsel purportedly discovered on April 11, 2021. This case is now in a distinctly different procedural posture than it was when this court granted Avery's previous motions for remand in the name of judicial efficiency, however. This case has been fully briefed. How is it fully briefed if they didn't have this witness since June 2020? It has been submitted to this court for a decision since November 9, 2020, without this witness. I'm adding the without this witness part. The parties have already expended an enormous amount of time and effort on briefing this appeal without this evidence. Presumably, this court has already dedicated a considerable amount of this court's scarce time and resources to addressing the issues already briefed as well, but not this witness. Given that this appeal is nearing its end, rather than in the pre-briefing posture it was when Avery previously sought remand, it makes more sense to conclude this proceeding and for Avery to then file a new Wisconsin statute blah motion once this case is remitted to the circuit court. As previously noted, a Wisconsin statute blah motion, quote, may be made at any time, unquote. And if, quote, the court finds a ground for relief asserted which for sufficient reason was not asserted, unquote, in a previous Wisconsin statute blah motion, the new motion is not subject to the procedural bar of state blah, 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 versus blah, blah, blah. If Avery can establish a sufficient reason for failing to raise this claim in the motions currently under review, the claim will not be barred and he can file a new Wisconsin statute blah motion once this appeal has concluded. If he cannot establish a sufficient reason for failing to raise his claim earlier, the claim is already waived and the procedural bar already applies. It would unduly prolong these proceedings further to remand now after considerable time and effort has been expended by the parties and this court, and this appeal is nearing conclusion. This court should deny Avery's request for remand. Again, they didn't know this witness existed when things were filed previously. 2. Avery did not conduct a reasonable investigation into his new Brady claim before filing this motion in violation of Wisconsin statute blah blah. Quote, at a minimum, the reasonable inquiry standard requires at least some affirmative investigation on the part of the signer, unquote. You don't know what Kathleen Zellner did to verify Sowinski's claim. You don't know. False swearing is a felony, and Avery's attorney has an ethical duty not to present false statements to the public, the state, and the court. Avery's motion shows, however, that his attorney conducted no affirmative investigation into this claim before filing this motion for remand. Again, A, you don't know what Kathleen Zellner has done. B, judge could have been ruling that day this person came forward that Kathleen Zellner found out about Sowinski. So it is important to rush that information to the court. Avery claims in his motion that Mr. Sowinski came forth on April 11, 2021. Avery then filed the motion at issue here on April 12, 2021, with the only factual support alleged for it, an affidavit from Sowinski himself full of vague allegations. Vague allegations that we've heard multiple people say they saw Teresa Halbach, they saw Stephen Avery, and all are told, we got this, we don't need your information. Little too familiar. Avery's motion does not state that his attorney made any effort to substantiate this claim. His attorney did not attempt to perform an open records request with Manitowoc County. We already know what happens in Manitowoc County with records and evidence. to see if this conversation ever occurred or whether any record of it existed before filing this motion. She did not... Wait, let me put a pause in there. Is this going to be like when Andy Colborn was working at the jail and he got a call saying they had the wrong person for Penny Bernstein, and he wrote no report on it until years later? Yeah, so let's worry about looking at their records because, you know, it's so factual and on time. She did not try to learn who this female officer Sawinski claims he spoke to might have been, or even which female officers were employed with Manitowoc at the relevant time. She apparently did not press Sawinski for any specifics about this allegation, you don't know that could allow her or the state to investigate it. Indeed, Avery's attorney apparently did not perform so much as a phone call to try to back up this information before filing this motion. There is no excuse for this lack of verification. You're dealing with Manitowoc. Asked and answered. There was ample time to investigate this allegation. As explained, there is no time limit for bringing a Wisconsin statute blah blah motion, and if Avery has a sufficient reason for failing to raise this claim in his previous motions, it is not procedurally barred. If he does not, the claim is already procedurally barred, and pursuing this motion for remand is a fruitless endeavor anyway. Avery's attorney did not have to rely on Avery for the factual foundation underlying the motion. Indeed, nothing in Avery's motion suggests he is even aware of this story, let alone that he provided any facts about it. And as mentioned, there were several ways to investigate whether there are any factual underpinnings for this tale. It was not impossible to investigate that such that Avery's attorney had to rely on Sawinski alone. This case did not originate with a different attorney, and post-conviction counsel has hardly made it a secret that she has been pursuing post-conviction relief on Avery's behalf for the past 6 years. And finally, while this case is complex, the allegations relayed by Sawinski and underlying the elements of a purported Brady violation are not. Quote, to perform an adequate investigation before proceeding with a claim, it is clear that an attorney may not simply rely on his or her client's word. Unquote. Well, this wasn't her client. It's a witness. It follows then that neither may an attorney rely simply on the word of a person like Sawinski, someone who appeared out of the blue for the first time, 15 years after this case began and long after Avery's appellate brief was filed. This despite extensive media coverage of this case. You don't know if this guy paid attention to the news. Particularly during the 5 years this post-conviction proceeding has been proceeding, and just fortuitously happens to provide the exact exculpatory story Avery has been seeking. Yet, for some unexplained reason, he failed to provide it to Avery's attorney until now. The need for an attorney to approach such claims with skepticism and to at least conduct some type of investigation before filing an affidavit attesting to this story's veracity is particularly heightened where, as here, the attorney has offered a $100,000 reward for such information. Quote, a paper filed in the best of faith, even when the lawyer is convinced of the justice of the client's cause, is sanctionable if counsel neglected to make reasonable inquiry beforehand. Unquote. Quote, the investigation need not be to the point of certainty to be reasonable. Unquote. Quote, nonetheless, the signer must explore readily available avenues of factual inquiry. Unquote. Quote, a statement that is offered as a positive fact but is actually an extravagant inference from vague recollection does not satisfy this requirement. Unquote. Avery's attorney did not conduct a reasonable inquiry into this claim. You don't know. Denying remand in this situation is appropriate. 3. Avery's many remand requests have been filed for an improper purpose, warranting denial of his latest request. The obligations listed in Wisconsin statute blah blah are independent, meaning that the statute has been violated if any of the prongs have been violated. Avery's disregard for Wisconsin rules of procedure and his persistent serial filings show that they have been made for improper purposes, to delay the proceedings, to continually change his position to make it difficult for the state to respond to his ever-shifting allegations, and to frustrate the court's ability to reasonably evaluate his claims by burying them in paper. Which, let me remind you, Kathleen's filing was just a couple pages. I mean, I think it was a page in an affidavit, right? This is 23 pages long. And you're getting multiple filings because more of their duplicity is being discovered. You gave away the bones. You didn't talk to a witness who saw Bobby with the victim's vehicle. So, who's burying stuff? Oh, that would be you who are giving evidence, bones, to the family to bury. But you said those aren't Teresa's bones. If those are Teresa's bones, their whole narrative falls apart, because Kratz's sweaty story is that Stephen never left Avery Salvage. So why are the bones all the way at the quarry? The gravel pit, not the quarry. Quarry is what's right behind him. Gravel pit's further away. But you're going to give those to the Avery family and do what? Bury them. Quote, improper purpose does not necessarily refer to bad faith or intent to harass, ... Indeed, any reckless disregard of the duty owed to the court can suffice, unquote. Avery has continually misrepresented the facts, misstated the law, and made claims grounded only in speculation with reckless disregard for their truth or falsity. Man, when you're pointing that finger, state, look at all the fingers pointing back at you. Avery's conduct shows that his many filings, including this one, were filed for an improper purpose. What's improper of a witness coming forward who says time and time again, years ago, they tried to come forward and everybody dismissed them? Avery has now filed 6 motions alleging claims that could have been raised in his first Wisconsin statute motion. No, they can't, because they didn't know about it at the time they first filed. He has ignored and attempted to circumvent Wisconsin statute blah blah by continually labeling his successive motions supplemental, despite the fact that each of his previous motions had been denied when he filed his new ones, meaning they could not be supplements to his previous motions. He has pursued diametrically opposed claims and submitted evidence that he reasonably should know cannot all be true. Compare Avery's 4th motion for remand, 1 through 4, accusing Strang and Buting of being ineffective for failing to establish Ryan Hilgas as the only possible third-party perpetrator and claiming Sergeant Colborn planted the RAV4, then alleging they were ineffective for failing to establish Bobby Dassey as a possible suspect with the same evidence, and now claiming Bobby planted the RAV4. Yeah, because different evidence has come forward. Yeah, makes sense to me. Further, Avery has inappropriately changed his arguments or raised new ones in his reply briefs, giving the state no opportunity to respond. He has buried and burdened both the circuit court and this court with thousands of pages of exhibits, many of which were unnecessarily repetitively filed multiple times. which, you know, we're reading these 23 pages right here that they're saying the same things over and over again. So who's repetitive? He has leveled completely unjustified accusations of bad faith against the state. And finally, he has disingenuously presented his claims to this court by affirmatively misrepresenting how and when he raised his claims below, changing his claims on appeal, adding new allegations he never presented to the circuit court, and materially misrepresenting the record. In short, Avery has engaged in a pattern of, quote, gamesmanship that offends the rules, ... and demonstrates a cavalier lack of candor with this court, unquote, in the circuit court. I mean, really? Again, you gave away the bones. You lied about the bones. You gave the bones back. You're hiding the RAV4. And you're going to say somebody else is offending the rules? The state is not seeking sanctions here. Oh, bless their hearts. However, this pattern of conduct shows that Avery's belated remand request has been made for an improper purpose. This court should deny his motion. What's the improper purpose? More evidence proving that an innocent man is sitting in prison for a murder he didn't do? Again, if Avery no longer wishes to challenge the circuit court's decision denying the claims he raised in the Wisconsin statute blah blah motions at issue here, he may voluntarily dismiss this appeal. As noted, his new claim is mutually exclusive with some of the claims he raised previously regarding what theory of defense he believes Strang and Buting should have pursued, and cannot be squared with many of the allegations in his appellate brief. The process of winnowing out weaker appellate claims and focusing on those more likely to prevail, quote, is the hallmark of effective appellate advocacy, unquote. Alternatively, if he does not wish to give up his challenge to the circuit court's denial of issues raised in the motions at issue here, he must wait until this appeal is resolved and then determine how he wishes to proceed. So again, wanting to delay because the court is taking forever in that. So instead of, oh, there's this new evidence, let's look into this new evidence and have this considered here, let's just wait and let them give an incorrect ruling without all the evidence. And then we'll start all over with this. Everything's going to take time. Doesn't matter. So why wouldn't you want to just pause and now look at this? But staying the appeal and remanding the case to the circuit court for fact-finding on another entirely new claim that Avery has not attempted to verify is not appropriate. Avery's request for a remand is contrary to Wisconsin statute blah blah, prohibition on successive post-conviction litigation. Conclusion. The litigation of a new Wisconsin statute blah blah motion alleging a new Brady violation is not a specific issue related to the order Avery is appealing. It is a new and separate action in the circuit court. Avery has alternative courses of action that do not require further delay to this fully briefed, not fully, submitted and 4-year stagnant appeal, which that's the court's fault. This court should deny Avery's petition. Dated the 16th day of April 2021 by Joshua Call, Attorney General, and Lisa Comfer, Assistant Attorney General. We will at some point post that so you can read it yourself. I haven't gotten around to sending it out so I can have somebody convert it into something that can be posted. Because as soon as I got it, I right away was going to Stephen Avery Project to read it, and then now reading it here for you all as well, so people are getting the information as fast as possible. Summarizing it, this is just the state's response to Kathleen wanting to put a pause in the current proceedings to go back down so they can bring up this new evidence, and hopefully the new evidence could be included in what they're already considering up here. And the state wants them to just ignore this evidence, get a decision here, and then start all over, or quit this and start all over. 6 in one, half a dozen in the other. No matter which way you do it, it's going to take time, and it's going to take court's time, judges' time, paperwork, investigating, all that. Money. So, it's all going to take time. This person says that they reached out on November 5th, 2005, and was told, we know who did it, and did not reach out to him to be a witness. We do not know what he knew about the case, what he thought about the case from 2005 to 2015, when Making a Murderer came out. When he watched Making a Murderer, he then reached out to Strang and Buting to tell them what he knew. Nobody returned his call. We do not know the full details of why he then reached out to Strang and Buting. My theory is he may have thought from 2005 to 15 that Stephen was guilty. And now he watched Making a Murderer, and oh my God, Stephen is innocent, and I saw somebody else with this vehicle. So let me tell the only attorneys he knew from that was on Making a Murderer. Kathleen Zellner didn't take over Stephen's case until January of 2016. Making a Murderer came out in December of 2015. So we do not know when he called Strang and Buting how he attempted to reach out to them. Was it a call? Did he leave a voicemail? You don't know who got that voicemail, what happened with it. It's a screw up on somebody's end. Don't know who. So we don't know why then from 2015 until 2021, nobody's heard from him. Is it because he's tried twice to tell what he knows and nobody cares? Does he think it's pointless for him to tell because what evidence is there? It's just my word. So maybe that's why nobody's talking to me? We do not know how Kathleen Zellner came into contact with him. Maybe they're going over all the paperwork in this case, and somewhere they found this guy's name. We don't know. So maybe this wasn't him reaching out to Kathleen Zellner, and that her team reached out to him. But why wouldn't you want to investigate it? Why just automatically try to dismiss this guy? Unless you're desperate to make sure it is Stephen who is in prison for this. So Stephen is not the one prolonging anything, especially now with his mother having dementia. Every day is precious. With Stephen's family saying they're going to move her to a new location and not let Stephen know where she is, so Stephen will have zero contact with his mother. You think Stephen wants this prolonged? He's already been in jail since 2005. And was in prison for 18 years prior to that. So, Stephen, not delaying anything. New information gets found. Information that the state buries. Literally. So now we wait for Kathleen's response to the state's response. And then we'll hear the court's response. Do not know how long it will take. I think it's always that the lawyers have a set amount of time. So Kathleen may have 30 days to respond. But then the court always has, infinity. That's what it seems like anyway. So how dare the state try to say that Stephen or Kathleen are the ones delaying this case when it is the court that puts it off for months and years before they rule on anything. It's the court who says, nope, yeah, we know the state has lied to you and they got rid of this evidence and let the family literally bury it. But we don't want an investigation into that. We don't want to talk about that evidence. Nope. No. It is Stephen and Kathleen Zellner that is trying to put all the information out there, all the evidence out there. It is Stephen and Kathleen Zellner who care about what happened to Teresa Halbach, who want justice for Teresa and Teresa's family. Seems that nobody else cares that Teresa Halbach went missing and there's somebody or somebodies still out there. Maybe they've done this multiple times. They're okay to have that blood on their hands as long as Stephen is locked away and that $36 million lawsuit went bye-bye. And if he gets out a second time, $36 million is laughable for what he's going to be owed. Especially when these are a lot of the same characters from his first case. And that he's lost his mother. As soon as Kathleen Zellner responds, or the court responds, we try to get it as soon as we can and bring it to you. So, I know I had plenty of people who were posting and messaging me saying, Jax, did you get it yet? No, because trust me, as soon as I get it, you're going to have it. I didn't even read this before I went live on Stephen Avery Project. I didn't even know what I was reading. I didn't know if this was from the court or the state. I had no idea. I don't know. I don't know the law. I don't know when you look at what was filed on what that even meant. I don't know. So as soon as something happens, we will bring it to you as soon as we get it. I jump through whatever hoops I have to. So like for this filing, I have to pay them 40 cents a page. Which I never understand because I'm not asking for a printed copy. I'm not asking for something to be mailed to me. You emailed it to me, yet I have to pay you 40 cents a page for it. But for this one, it's no big deal. It's $9 and change. But for past filings, when there's all these exhibits and everything, it's a lot of money. And luckily, Kathleen posts a lot of it on her website, so then I don't have to pay for it. But as soon as we get anything, we'll go live. I go live on Stephen Avery Project first, and then I come in here with y'all to dish about it. So, but I'm going to bring this one to an end because I was already live on Stephen Avery Project live here. I don't know how long I've been doing this. My dogs want to go out, and I actually have to be at a meeting tonight that I'm still in pajamas. I haven't showered or anything because I've been sitting here watching a trial on TV, and I'll shower later, watching the trial, and I was waiting for breaks in the trial to shower, which they're breaking right now, and now the final closing argument's about to happen, so now I'm going to have to just wait until it's all over before I can shower, before I go out to a meeting tonight. So you don't have to keep asking me. When we get it, I'll bring it to you. Something else before I go, I'm probably going to make a post about this as well, but we're getting notifications from Facebook that Facebook has been removing some people's comments for hate speech or bullying or whatever. So Facebook is apparently getting very, very touchy with vulgar language, which really hard for me because I have a very bad potty mouth. So just know if you've made some comment and it's been removed, that's, Facebook's going over everything with a fine-tooth comb. Well, not a fine-tooth because nothing's happened to me, knock on wood, so far. But I'm also going to try and get better with my language so I don't get censored. So just know that using some naughty words could have Facebook bring the crackdown on you and maybe put you in Facebook jail. And that's not us doing it, it's Facebook trolling and taking control of things. So, all right, I'm out. Thank you everybody for being here. I will try and get this posted to sometime today so people can read it for themselves. So, investigation continues.